Hello, everybody. We are delighted that you've come to join us this morning for a bit of a talk about the Supreme Court's decision in Poole and Royal Wolverhampton. I'm Emily Formby, and I am joined today by Scarlett, Milligan and Charlie Cory-Wright, who are obviously sitting next to me. We are talking for about an hour, and we've already realised in our sort of preparation and discussion that we've got much too much to say for an hour. I mean, that might not surprise you, but we are going to do our best to get through what we think are the key issues. We've got slides that you'll see now, which will be available for you on our website later. And what we've already decided is, although in the slides we go through Lord Borough's dissenting judgment, we're not really going to talk about that today. We're going to try and talk about some of the more interesting issues we think arise from the decision. So we're going to give you a short reminder of the law before Thursday, last week, Thursday the 11th, when this judgment was handed down, and a bit of a discussion, as I say, about the main changes, and hopefully a reflection also on what that might mean for practice going forward, both clinical negligence and personal injury. So it's a little bit of a crystal ball. And we're hoping this is a bit of a reflection and interactive session between ourselves, because we've all obviously just been getting to grips with the case over the last few days. We also hope that you may be able to participate too. So we've got a question and answer box that you should be able to see. If you want to put a question up for us, we'll be able to see those. We will try and answer them as we go along. But again, pressure of time, we might not be able to, but we will certainly come back and answer them, if not in person, by email afterwards. So grab a coffee, draw up your chair, and let's begin.
Okay, thank you. Hello, everyone. Just before we dive into the detail of all of this, we thought it might be sensible to pose 4 questions and give a very brief summary of the answer as a sort of taster, trailer for what's coming over the course of the next up to an hour. And the 4 questions are as follows. First of all, pretty fundamental ones. What are secondary victims? Easier to ask than to answer, as we've been discussing as we talked about this over the course of the last few days. Secondly, why has the law found them so difficult to deal with? Thirdly, what was it that Taylor and Novo, which was the case that Poole arose from, and the Court of Appeal found itself bound by, decided, and why was it controversial to practitioners? And fourthly, what has Poole now decided, and why is it controversial to some practitioners? So the first question, luckily, the answer, what are secondary victims? The answer was given by Lord Legate, and it's actually, we'll come to this in a moment, you don't need to see it now, but it's at paragraph 4 of the Supreme Court judgment, his speech there. And what he said was this: it's a limited category of cases recognised by common law in which damage may be recovered for personal injury consequent on the death or injury to another person. In these cases, it's not the death or injury of that person itself or the defendant's responsibility for it which gives rise to the claim, but the fact that the claimant has witnessed the wrongful death or injury or threat of such death and injury to someone they love. So that's the territory we're in. By the way, I probably should say the speech that was given was not, that speech was given jointly by Lord Legate and Lady Rose. So please take it. If I don't refer to Lady Rose or Lord Legate, I mean them both. Second question, why has the law found them so difficult to deal with? Well, there are 2 ways of answering that. The first is they are exceptional. They are outlier cases. They are cases which don't fit into the normal rubric of the common law. And the other way of looking at it is that they are also, by definition, nearly always extremely tragic in nature. Now, those of us who deal with personal injury or clinical negligence cases regularly deal with primary victim cases which are obviously tragic, but there is something so atavistic, so fundamental about the idea of a case being brought by a parent who has seen their child die or something of that sort, we all shudder at a human level when we see this. And that's the reason why judges are the same. And that's the reason, I think, why these cases have created such difficulty, and people have gone through very strange hoops in order to find liability, as well as in order to trying to find a coherent system of law about it.
As Charlie knows, I think that's a little bit of a cop-out. I'm not sure that that is the reason. And one of the things we're going to talk about and explore as we go through the slides, as Charlie just gave us a bit of an introduction, I think it's because people have just fudged issues that are difficult, and it makes it harder and harder to unpick as you go along. But without doubt, I mean, I wasn't meaning to say they're not tragic. They're absolutely tragic, but I personally don't think the secondary victims are of a scale of disaster or horror different from many of the claims that you see happening to primary victims or happening on a personal level, other than perhaps the agglomeration of horror that was Hillsborough. And that may well be one of the problems, that actually two of the main cases are dealing with what is acknowledged to be just a truly terrible set of affairs. But
I do agree with that.
I'd say, why was it controversial? It shouldn't be past tense, it clearly still is controversial. There are many views.
Exactly. Anyway.
The reality is that they occupy, in these cases, a hinterland between the place where a duty in law is owed and the place where a duty in law is not owed. And that's the legal reason why they cause problems. Which takes us to the third question: what did Taylor and Novo decide, and why was it controversial? Taylor and Novo, for those who aren't aware of it, was the case where a set of shells fell on an employee, and 3 weeks later she died in front of her daughter as a result of injuries sustained during this. And ultimately, although her case succeeded at first instance on the basis that the relevant event was the daughter witnessing the death and the daughter witnessing it, as opposed to the accident of the shells falling down, the Court of Appeal allowed the appeal against that judgment on the basis that there was no proximity between, important to stress this, there was no proximity between the claimant, the secondary victim, and the tortfeasor, which is what is needed in order for a duty to be established. And that case disavowed the idea that you can have two events and choose which of them you go for. Paul went to the Supreme Court because the Court of Appeal had found themselves bound by Taylor and Novo and didn't like it. They didn't like the consequences of Taylor and Novo and thought it should be examined afresh by a higher court. But that higher court, in an attempt, I believe, and I think we're all agreed about this, to simplify and make more coherent the system of law that we are applying, essentially said Taylor and Novo is right, no proximity, no legal proximity there to the secondary victim. What is important is that there is an accident, and we'll come in a moment to what's meant by the word accident, which is a slightly loaded term in this situation, which may not have been recognised entirely by their lordships. But anyway, there is an accident which is witnessed. And for those reasons, clinical negligence cases nearly always, not quite always, but nearly always will fail if the secondary victim claims based on clinical negligence, because there won't be the equivalent of an accident to be witnessed. So that's where we are. Important to reflect on the fact that the consequences of Paul are not just clinical negligence consequences, they impact upon secondary victim cases as a whole, and we'll come to that in a minute. Sorry, that was rather longer than I intended, by way of introduction, but anyway.
By way of, sorry.
No, because then the risk of your introduction and your overview becomes the whole talk. Right, anyway, let's crack on, because that is, I mean, it's important to set out those parameters.
That's our roadmap, and now let's start the journey. So we thought it was best to start with the difficult question of what secondary victims are. We're not going to go into the nuts and bolts, but just by way of reminder, primary victims are those who've sustained in breach of the duty of care, physical injury, or psychiatric injury where that was reasonably foreseeable. Whereas secondary victims, the key distinction here is they are injured psychiatrically by virtue, typically psychiatrically, by virtue of witnessing their loved one being injured, or perhaps fearing it. It's important to remember that secondary victims don't require the primary victim to actually have been injured, and that's a difficulty that we'll encounter as we go through. We flagged there, as indeed Lord Burrows did in his dissenting judgment, that way back when in 1998, the Law Commission said this whole area needs reform, and Lord Burrows was in fact the Law Commissioner with responsibility for that report, which he mentions at the outset of his judgment. And I think the government responded many years later, something like 2007, don't quote me on that, but saying back over to you courts. So that's why we are where we are in 2024. So the Supreme Court's judgment handed down last Thursday was heard by a panel of 7 justices because of its importance. As Charlie said, legal judgment given by Lord Legate and Lady Rose, with whom all, save for Lord Burrows, agreed. We're probably not going to have time to get into why Lord Burrows disagreed, though it's in the slides. And equally, we're not going to be looking at Lord Carloway's judgment on the impact on Scottish law. We have set out, in our view, that the judgment contains effectively 2 main strands of reasoning, and we've referred throughout our slides to strand 1 and strand 2. Strand 1 is effectively case law on secondary victims, how we got here and what form decides in relation thereto. And strand 2 is all about broader case law on negligence, on the duty of care, proximity, and why and how that's relevant to secondary victim claims.
So I'm going to just very briefly go through the facts of the 3 underlying cases, because that I think is important to bear in mind for the wider discussion. And it's also important and interesting, as Scarlett said, that there were 7 Lord Justices and Lady Justices sitting in the Supreme Court, because they were anticipating and wanted the ability to overrule their previous House of Lords judgments, particularly in reference to Alcock and Frost. Although they didn't in fact end up doing so, but they'd given themselves as broad a range as possible. So the 3 cases were all clinical negligence cases. The first, Paul Wolverhampton, which is the lead name as well. Firstly, all of the cases have never been determined on the facts. They're all strikeouts, so the facts are all assumed to be true for the purposes of bringing the qualitative legal assessment. Mr. Paul came, his 2 young daughters witnessed Mr. Paul's death. Their father suffered a cardiac arrest and collapse in 2014. He had a heart attack and died at the same time, very shortly thereafter, which was caused by an occlusion of his coronary artery. Effectively, he had an underlying atherosclerosis. The claimants say the defendant had negligently failed to diagnose and treat November 2021, so some time before. The fatal accident was the first sign of illness that he or anyone knew about, any consequence. And it was witnessed by his young daughters, who then suffered psychiatric illness. So what we have here is what is undeniably a shocking event, although we'll go on to the concept of what shocking and horrifying means, but a single event, a single incident. So again, bear that in mind, because we're going to talk about the concept of accident. There was no harm before the moment of his collapse and death that was apparent to him. Whether or not something could have been picked up by further scanning or screening, again, is something we'll look at. And it's negligence by omission, not action. They all are, and again, the concept of omission and action are not relevant here. It is deemed that omission is obviously capable of arising a breach. So again, this is the point at which the tort in relation to the primary victim was completed. There was a breach of duty, failing to diagnose illness, a causation and harm was suffered at the same point as the proximity of the witness by the secondary victim. Going on. Sorry.
Before we go on to Polmear, I've just spotted Charlie spotted a typo in our slides. Apologies. So the 3rd bullet down says November 2021. It should be November 2012. So scribble that out as you go.
That's my mistake. We can we'll make sure we've got them sorted out before we put them up for you for the final version. Sorry, team, that was my job. Polmear and Royal Cornwall Hospital NHS Trust. This is the tragic case of Esme. She died when she was aged 6 in July 2015. Now, from August 2014, her parents had sought help from the GP. Basically, she had symptoms of breathlessness on exertion. And she was referred to a paediatrician, which should have led, it was agreed by the January 2015, to diagnosis of a pulmonary veno-occlusive disease. She'd had an ECG that hadn't picked anything up at the time and was discharged. Anyway, if that had been picked up, treatment would have prevented her death. As it was, she was back within the system. They were seeking further help. There was a paediatric review that hadn't happened at the time of her death. She fell ill at school due to exertion. Her father was called. He carried her when she was too breathless back to the school. Then she collapsed. He tried to give her mouth-to-mouth resuscitation. The mother arrived also and witnessed the unsuccessful life-saving attempt of the paramedics. They both suffered psychiatric illness and PTSD and depression. So this isn't a single event or accident because there was a known illness that was undergoing imperfect but some kind of medical overview. She'd been recognisably unwell for 7 months, and there was that period of time of failure to treat her illness. So from the point of view of Esme, there's been a complete tort with a breach of duty. Her death on the 1st of July, again, we've got that arc of time proximity we'll talk about in terms of an unfolding event of being present at the time of death or at the time of her collapse, and the short duration between the mother arriving, seeing what happened, comes within the 2 hours margin of accretion that McLaughlin has set as an average time boundary. So those are the points to remember about that case. Third case, Purchase and Ahmed. This is the case of Evelyn Purchase. In April 2013, she died of pneumonia when she was aged 20. Her mother had accompanied her to the GP on a previous occasion. Her illness wasn't recognised. She was sent home with inappropriate treatment. 2 days later, she was still at home and she developed heart palpitations. Having left her to go out that evening, Evelyn's mother returned to find her motionless, holding a phone. It wasn't clear, but in fact, at that point, she was already dead. But she tried to call for help, and in fact, her dying breaths and her laboured breathing were recorded on the mother's mobile, which she then heard. Her mother tried to give a mouth-to-mouth resuscitation, which failed, and as a result of that, her mother developed illness for which she makes her claim. So again, clearly there was illness and symptoms before death. The shocking event of the actual death wasn't witnessed, but she had died within 10 minutes before her mother came home, which fits within the McLaughlin time. And of course, it was still an unfolding event. Nothing had been tidied or cleared. And indeed, when treatment was given, there was discharge of blood and other matter. So it was very much an unfolding event. A breach of duty by omission and failing to treat. But again, the primary victim wasn't one event, unlike Paul. There was a developing arc of illness getting worse. And again, going back to Lord Burroughs, looking at the point of actual death being the point that gives rise to the secondary victim claim being the dissenting judgment, is something that we'll look at in terms of proximity when we look at the rest of these cases. Because, of course, one of the other problems is many of the words and the descriptions used cover quite a lot of things: proximity in time, proximity in place, proximity in relationship. It becomes a very confusing set of issues to keep clear in your head as to what you're talking about when. So the progress of the case is very simply, they were struck out at first instant. Paul, then it was overturned on appeal by Chamberlain, and then came up through up to the Supreme Court. Polmear was game again. They were both before Master Cook. He refused to strike it out because of Chamberlain's judgment, which was in favour of Paul. Purchase was struck out again in the county court, and all three decisions were joined in the Court of Appeal. All three were dismissed, but were given permission to the 7-court Supreme Court, where they now fetched up last Thursday's judgment. Which says what?
5 more minutes left. So, starting with the background to what the Supreme Court is deciding, what they're having to look at, I think that Charlie's observation about these being very difficult cases and outliers is apparent from the opening paragraphs of the judgment, and no doubt that the justices had that in their minds. And they start by saying, broadly, the common law doesn't compensate one for witnessing the death or the injury or the apprehension thereof of a loved one. That's just not something the law is deemed having to compensate. There are 2 exceptions. One is claims brought under the Fatal Accidents Act. That will allow a sort of tariff payment or bereavement for certain categories of individuals. But the second is the common law case law in respect of secondary victims, but they are, as Charlie said, exceptional. On the next slide, we've set out in full for you paragraph 4 of Lord Leggett and Lady Rose's judgment, saying they're limited to categories of cases. In these cases, it's not the death or injury of that person itself or the defendant's responsibility for it which gives rise to the claim, but the fact that the claimant has witnessed the wrongful death or injury to someone they love. And that witnessing is a key concept that we'll keep coming back to.
It is just worth remembering, Charlie read that out before, but of course it can also be the perception of injury. It doesn't have to be the actual death of injury,
Yes.
although that's not what it says there.
And that's one of the issues that I had with the judgment at times. It simply says death or injury, and it doesn't always include,
It doesn't always caveat it.
apprehension thereof, and that's something that we need to be alive to.
But it does mean
analyse
it.
this. Yes.
Yeah.
We've been rewriting the judgment in our own time. So there are the judgment is. I commend it to anyone interested in secondary victim claims. It goes through all of the case law. It's a really helpful analysis. It takes time, but it's worth it. We're not going to replicate that analysis here today, but we thought it worth highlighting 3 significant House of Lords judgments upon which fall has its foundations. The first is McLaughlin O'Brien. It's not actually on your slide, but Emily has already referred to it as setting the 2-hour temporal bounds for the immediate aftermath of a distressing event, accident, whatever terminology one wants to use. In that case, the House of Lords did say effectively this is on the cusp. And I would generally, my view would be it's not simply about saying, well, 2 hours is your limit. In that case, the loved ones were still untreated, unwashed. They were very distressing to see. And so the way that the Lords looked at it in that case was to say it still was part of the accident in a way that it could adequately be described as the immediate aftermath.
But they have sought, haven't they, because the Supreme Court have disavowed a couple of other road traffic collision cases when, without doubt, the secondary victim came in the aftermath, either finding someone on the road or seeing them in hospital. But there's a bit more time, and they've disavowed those cases. So while it's not a hard rule, I would imagine you're going to have a tricky job to get much.
It's up against it, and the Supreme Court sort of said, remember that this is on the bound of what's recoverable. But it did occur to me that might be a new, effectively, area of debate. Where does one draw the line with the immediate aftermath? What does an accident include, etc. The second case of importance to the House of Lords is Alcock, which many of you watching will be familiar with. That was the first definition of secondary victims in terms of effectively how we know them now. Secondary victims being no more than the passive and unwilling witness of injury caused to others, or the risk thereof, the fear of apprehending that. And then in that case, Lord Oliver defined the common features of secondary victim claims, leading to the essential requirement of proximity. And this is an important point that Emily was just touching on. We have overarching proximity between a tortfeasor and a claimant, whether a primary victim or a secondary victim. Within that overarching proximity, the 4 control mechanisms, as they were then called in Alcock, are looking at effectively ways to establish that overarching proximity. But because the term proximity then gets used by reference to temporal proximity in space, at times there is a bit of confusion as to what we're looking at for proximity. And I think personally, the way I think about it, it's really helpful to remember that overarching arc of proximity that the law requires. So those 4 control mechanisms were, as then, a marital or parental relationship. Now the loved one is broader than that now. The secondary victim's injury arose from seeing a sudden unexpected shock to the plaintiff's nervous system. Again, we'll come on to explain that's somewhat advanced now. The third is that the secondary victim was either personally present at the scene of the accident or more or less in the immediate vicinity. And fourth and finally, that the injury to the secondary victim arose from witnessing the death, extreme danger or injury, discomfort suffered by the primary victim.
And kind of in a nutshell there, I mean, obviously you get that sort of space-time continuum like Doctor Who, but really the Supreme Court have nailed their colours to number 3, so the secondary victim being personally present at the scene of the accident, under that, whereas kind of Lord Burrows goes for 4, which is the witnessing the death or the extreme danger of injury to the primary victim.
Yes.
But so 3 is the one to remember because they changed 2. Anyway, we haven't got that yet.
And then finally, we can take Frost a little bit quicker. That's the final case, which arose from the police officer's claims arising out of Hillsborough, and Lord Oliver was urging caution in that case against extending this proximity concept to include effectively too many people. It was agreed in Frost that the Alcock requirements needed still to be met. They're restated there. We've already alluded to that. I won't read that out verbatim. But Lord Stein in that case set out some policy reasons as to why broadening the category of secondary victims and those who fall within it was disproportionate to not only the defendant's fault, but really their duty of care. And so we're going back again to these fundamental concepts of duty and proximity, and that plays out in Paul's reasoning.
I mean, the Supreme Court tried now to kind of distance themselves from those sort of policy reasons. And so I think that goes back to the recognition that really making law around Hillsborough is an uncomfortable job, frankly. The only thing they did really consider was the role of the defendant and whether it was going to become too much of a burden or a disproportionate burden to the defendant.
Yeah,
with the kind of own policy floodgate type thing.
Yeah, and that ties back into duty of care, which is strand number 2, which we'll come on to. See, it's all. So the Court of Appeal's judgment in Paul, we've already said effectively that the Court of Appeal found themselves bound by Taylor and Novo, and I think Charlotte said didn't like it. We've got Sir Geoffrey Voss's quotation there. If I was starting with a clean sheet, I can quite see why secondary victims in these cases ought to be seen as sufficiently proximate to the defendants. There's that link there, that arc, to be allowed to recover for their damages. So on and up, the Court of Appeal themselves gave permission for the cases to go to the Supreme Court, where the key issue, they said in paragraph 5 of the majority judgment, was whether this exceptional category of cases includes, or if not, it can and should be extended to include cases where the claimant's injury is caused by witnessing the death or injury, not in an accident environment, which is the historic genesis of these cases, but from a medical condition which the defendant has negligently failed to diagnose and treat, and/or treat. We've said there that you do need to remember that the Supreme Court, the point that Emily and I were making earlier, accept that there's the sort of that a secondary victim claim can arise where one perceives danger, even though the primary victim actually never comes to any harm. It may not have even been possible, but it's all about that perception.
I think it is one of the odd and interesting things about, as you were saying, of all the concepts of proximity, that the one they've really latched onto, and partly also because Dyson goes on about it, emphasises it in Taylor and Novo, is the concept of an accident arising from something arising from an accident, and that a medical claim is intrinsically different to a personal injury claim arising from an accident. But I don't know. I mean, well, firstly, I can't help but find it a touch annoying that they use the word accident so kind of freely, when all of us that work in the personal injury space know there's been so much attempt to remove the word accident from the descriptions of road traffic collisions, because inherent in the concept of accidents is that it is nobody's fault, and inherent in the concept of tortious liability is that there is responsibility. So that's slightly great somewhere in the first place, and it just, you have that feeling of thinking about one thing and forgetting to reflect upon what that means to another.
They do caveat that in the judgment though, don't they? They sort of say, I think I've got paragraph 52 saying, you don't mean no one was to blame, but I know.
No. I mean, I accept it's probably my fault. I accept that.
I think it is an old chestnut, this one, and it's nobody's quite right to raise it. Because in the insurance context, accident can mean something that happens through no one's culpability or indeed agency, or it can mean simply something unexpected, which no one intended. And clearly, in this context, the latter definition would cover a tort like this. One way of dealing with it is to notionally to think to oneself what they really mean is incident. The important factor, I think, that the Supreme Court was getting at is that there has to have been an event that was witnessed. And it's of the nature, of course, of most clinical negligence cases, and indeed most clinical practice, that there isn't an event that someone would see that would then give rise to the sort of thing we're talking about in secondary victim claims. It's all occult, it's all happening without anyone noticing much of the time, unless it's their job to do so.
But I think the problem you get with that is you do just get a bright line being kind of made. And maybe that's the point of judgment, is you have to make your line somewhere, because we all know that you can have an accident is a pivotal event, say a road traffic collision. I mean, one of the things they talk about a lot is when you have a road traffic collision, you know exactly what the event is, but you can perfectly easily have that collision because you've had brake fluid dripping for 3 months out of your brakes. I mean, not necessarily 3 months, but you know the point. I mean, you know, because you had a negligently performed service, and as a result, you've had a long-term brake problem that's been building up, and one day it ends up you driving into something. You've got a very defined collision, but you've had a long tail of both negligence and indeed possibly some underlying consequences. You've been pressing the brake and it hasn't been working quite as well. And that was exactly the distinction being drawn between first manifestation of event, which we'll come on to, or as you said, Johnny, the idea that if you've got a clinical negligence undiagnosed or untreated or mistreated problem, it will be rumbling on for quite a long time without necessarily anything starting happening. That can be true, but not always, both ways round. So although I see what they are attaching, I don't think it's necessarily a definitive answer.
I agree, and have nothing to add.
Oh, okay.
Well, we've pretty much done that slide unintentionally.
Okay.
So where are we
so
now?
so that takes us to strand one, which is the specific secondary victim analysis here, and focus on Taylor and Novo, as the Supreme Court did. And at paragraph 89, they refer to the fact that the Court of Appeal didn't like the fact that they were forced to come to the conclusions they did, and because they were bound by it, bound by their own judgments. And then they go on to say as follows: this court, this is paragraph 90, this court is not so bound, but we agree with the Court of Appeal that the present claims cannot succeed unless we conclude that Novo was wrongly decided. We disagree, however, both with their interpretation and with that of Mr. Justice Chamberlain of what was decided in Novo. In our view, the analyses of both courts below share the common flaw that they treat Novo simply as a case in which there were two events separated in time in which injuries caused by the defendant's negligence occurred or became manifest, and view the fact that there was an accident as if it were an incidental feature of the facts, not material to the decision. This ignores the insistence in the judgment of Lord Dyson that what mattered was not the number of events, but the fact there had been an accident. And then lower down in that paragraph, the reason why the claim in Novo failed was that although there was an external traumatic event, i.e. an accident, we might put in the word incident instead, perhaps, which immediately caused injury to Mrs. Taylor, the one who died, the claimant, her daughter, did not witness that event, and the event which she did witness and which caused her psychiatric illness was not an accident. The proximity or lack of it from the claimant to an accident was therefore critical to the court's reasoning. And I would add, and I think I do so without doing any violence to Lord Dyson's judgment in the Court of Appeal in Novo, the proximity or lack of it of the claimant to the defendant tortfeasor, because that was part and parcel of the same point. So that's the first distinction about Novo, and then there's another, and its interpretation in the Court of Appeal in Paul. And then there's a second one, which is helpfully in the following paragraph, paragraph 91. In disagreement with the Court of Appeal, we do not read the judgment in Novo as suggesting, this is a different point, suggesting that the length of time between the defendant's negligent act or omission and the event witnessed by the claimant and which caused her psychiatric injury was a relevant factor. Lord Dyson didn't doubt that if the claimant had been in physical proximity to her mother at the time of the accident, in other words, when the shelves fell down, and had suffered psychiatric illness as a result of seeing the accident and the injuries sustained by her mother, she would have qualified as a secondary victim on established principles, adding in there, however long it was since the shelves had been put up. But as Mr. Justice Chamberlain pointed out, Lord Dyson said nothing to suggest the position would have been any different if the accident in which the stack of boards fell over had been caused by negligent stacking weeks or months before the accident occurred.
So that, in a way, that's kind of easy to understand, because that's the concept of the difference between a breach of duty and the possibility of a completion of a tort. Because the breach of duty is the misstacking of the shells. But of course, they could have sat there forever, and unless they fell over and actually hurt someone, although they'd been, you know, negligently stacked, as in a breach of duty, it wouldn't have caused any harm. It wouldn't have been a tort. There wouldn't have been a primary victim. So you can kind of see that, and they also give the example of the RSJ being put up years in advance, and then it finally drops on someone's head. But I think what's sort of harder about that concept of accident, and it maybe we're talking about things that are going to come to light in the further slides, but I think it's worth sort of saying now, is that of course there's nothing to stop there being that sort of accident or that kind of witnessed event being some time after the completion of the tort. So if you'd had the event being witnessed by the secondary victim, as in when the shells fall down and that led to the catastrophic event, then of course that would be recoverable. That's what Novo's saying. If the secondary victim had seen that, because that's the proximity of time, being proximal to time. But with a negligent treatment, negligent mistreatment, I'm not quite sure why this is impossible to have an event that arises from the negligent treatment that's witnessed and is a significant event, witnessed by the secondary victim, that can't give rise to a claim.
Isn't that what Lord Leggett and Lady Rose were referring to when they said, we're not going to rule out the possibility that accidents, as we're calling them, as in the sense that we're using that term, can occur within the clinical negligence context. But let's leave that for the cases where they arise.
Although they sort of do. But anyway, we'll come to it. Yeah.
So, and just to complete the point about, can you go to the next slide, which is where we are already, thank you. Watch the ball. An occurrence or manifestation of injury is not part of what defines an accident. An accident is an external event which causes or has the potential to cause injury. It is not the injury, if there is one, caused by that event. Witnessing injury caused by the accident has not been treated as either necessary or sufficient. And they made the observation, the earlier secondary victim cases in the medical negligence context didn't decide whether in principle the rules developed in accident cases ought to be applied, and simply assumed that the same rules applied and focused on the application of the sudden shock Alcock criteria.
So what I've been whistling on about for a while now is why witnessing the accident is legally significant. And the Supreme Court have held witnessing the accident is legally significant because, and this is their reasoning for it, one, you get a category of victims that's legally certain. That's paragraph 108 of the judgment. 2, witnessing an accident or an incident involving a close family member is an intelligible place to draw the line on recovery of damages for illness consequent on bereavement. That's 109. And it can be difficult or arbitrary in incident cases, to distinguish between primary and secondary victims, and no reasonable distinction could be drawn between injury caused by fear for one's safety versus the safety of a close family member. We're just going back over those last two. Obviously, when they talk about consequent on bereavement, that's because all of these cases did end up in death, although they were talking about it could be harm or injury without it being death. It just happened these were bereavement cases. But on the third point, the reasonable distinction between injury caused by fear for one's safety and safety of a close family member is because often in discussion they've been talking about the analogous offending of where a line should be drawn of mothers and children. So the idea that if you were crossing the road as a mother and you were carrying your child and you were hit by a car, or there was a near miss by a car, and your fear arose because you thought you were going to be hit by a car, and you suffered injury as a result, and or you were hit by the car, you were a primary victim. Or if your fear is because you thought your child was going to be hit by a car, and that was your concern, you wouldn't be able to recover unless a secondary victim claim was enabled. And the courts have all said that would be just ridiculous. Of course you should be able to, effectively by being noble-minded and worrying about someone other than yourself, you're precluded from recovery. So that's where that distinction, fear for one's own safety versus safety of a close family member, arose. Although I do think it does lead to some kind of complicated double think at a later stage. Anyway, defining the accident, as we're going to continue to do. So the majority judgment, as we've been hearing, have clarified the following are not requirements for a secondary victim claim. Now, firstly, and interestingly, they've removed the requirement for horrifying by objective standards, like the concept of the nervous shock. And that's 75, 76, really because of the development of medical science and understanding of psychiatric injury and the triggering for psychiatric injury that has occurred since secondary victim claims, going right back to Julian White and, Borhill and Young, when effectively women had the vapours and men were, striding strongly along whatever. The concept of development of medical standards is such that the nervous shock isn't required anymore.
My goodness.
Yeah. However, although the concept of no Richter scale of horror and the truth is unavoidably subjective, it is right to say that still within a clinical diagnosis, as we know, you do have to have a shock that's capable of giving rise to PTSD. So the sudden apprehension of an event being a medically required component of a defined psychiatric illness is different from a load of judges sitting around and deciding whether or not something would turn the stomach of somebody of reasonable fortitude. And so I suppose the answer is elevating it to expert evidence. Which
the takeaway is that this is now in the province of the experts.
Yes, okay.
And rather than the claimant subjectively or the judges.
No, exactly. So you will still, it's not overturning the diagnostic criteria of PTSD, it's a clinical, what he said. Right, 2, a sudden and unexpected shock to the nervous system as opposed to gradual assault on the nervous system. You don't need that anymore, which was tied to an outdated theory. Once again, they're tidying up psychiatric illness and what we understand by the triggering of injury. So it's sufficient to show a causal connection between witnessing the accident and developing psychiatric illness, as long as you've got over all of the multitude of proximity tests, etc., etc. And thirdly, considering whether an accident is one event or several separate events is neither helpful nor a formal requirement and risks expanding recoverability far beyond the immediate aftermath contemplated by McLaughlin. Now, essentially, 79 to 82 paragraphs of the judgment will help you there. There's a general review, as Scarlett said, which we're not going to go into, but a lot of the old cases, and in particular Walters, which has been disavowed, which is the 36 hours of Sophoclean disaster developing the tragedy of the baby dying. But essentially, whether you've got one event, whether you've got blow after blow, that's all gone, says the Supreme Court. And so one doesn't have to make those infinitely cut the symptoms anymore.
I'm going to race through this slide because we've touched on it already before we were meant to. Probably my fault. But essentially, the difference between the timing of the negligent act and the delay between the time the negligent act and the horrific event which it caused doesn't affect the defendant's liability so long, of course, as the horrific event was the event which was the accident for the purposes of the Supreme Court's.
We committed the cardinal sin of eating our pudding before our bed, didn't we?
All at the same time. The other point, which was a point of distinction, this is the next slide, the point of distinction between the cases, as we've already heard, that were before the Supreme Court. Paul was a case where the first manifestation of damage was the one that was seen by the secondary victims. Polmear and Purchase were not, hence differences in the argument advanced by the claimants in relation to them. As we say, it's inherently difficult to define first manifestation. Is it harm? Is it really serious harm? Is it any symptoms at all? Is it symptoms noticed by the primary victim? Is it something internal to the primary victim which you can't see if you're not the primary victim? All of these things are too complex to form the basis of a sensible way of testing this, which is another aspect of the simplification process which the Supreme Court has undertaken.
Except the only thing I do think is really interesting is in the process there, they give a clue to what might have been a better solution. She says, dare she say that? But at paragraph 99, they're talking about exactly the problem with Paul, even though he was talking about the first manifestation of damage and hadn't been ill until he had the heart attack. The question of whether there could have been angina or even raised blood pressure you didn't know about and these hidden things. But what they do describe is they would have avoided they talk about the medical crisis, so whether you'd had these things before the medical crisis occurred on which the claims are founded. And I do wonder whether in fact what you could then explore is the idea of a medical crisis being equivalent to an accident. And if you witness that medical crisis, just as if you witnessed a road traffic collision that was caused by something that had happened a long time before, in the road traffic collision, you'd be able to qualify as a secondary victim, but in the medical condition, you can't, because the medical crisis isn't allowable.
Which brings us probably quite well onto strand 2 and why it's not allowable and some of the things from there.
Yeah. Oh, we've got a question about PTSD diagnosis about a qualifying trauma akin to the old sudden shock of other psychiatric conditions you do not. And claims may be made regarding other psychiatric conditions and secondary victim claims, not just PTSD's how it is affected by new judgment. So I think the short answer is it's not.
Yeah.
That's perhaps what I was poorly trying to say. Any recognisable clinical psychiatric condition is capable of founding a claim.
Yes.
Page and Smith has been confirmed. There's no change.
It's certainly the case that the majority of secondary victim cases are cases where PTSD is said to be the damage that has been caused. But you can have adjustment disorders and other such lesser or different in quality illnesses which do not have the same requirement in diagnostic terms for shock, i.e. the old test, in the nervous shock type test, which has been disavowed now. So yes, it's
only relevant in medical causation, really, isn't it?
Yeah. Right, we're coming on to strand 2 as we romp through the hour. 8 minutes. Oh, 8 minutes, no problem. So where does this analysis fit within the broader law of negligence? Where indeed, you could say. But the general principles of negligence can't be ignored or bypassed. You've got to have the legal proximity between the secondary victim and the defendant. The question is one of interpersonal justice, as they say, all the paragraph numbers are there. So the scope of the defendant's duty is also important, and there was consideration about the scope of the doctor's duty in general. There's got to be a sufficient nexus between the harm claimed for and the defendant's duty of care. So just that point very narrowly being Meadows and Kine, it's not just any old doctor is responsible for any old thing and whatever it is. So Meadows and Kine, you remember, was the case when there was advice in respect of haemophilia and whether or not there was then a duty in relation to subsequent development of autism. Short answer, no, of course not. So that's the first thing. The scope of the duty is important. If you're a blood doctor, you're not expected to understand about or advise about anything else.
And we've got another question about. Since I've read it, I'll have a go at answering it, and then Emily and Scarlett can tell me why I've got it wrong. The question is. Thanks for the helpful discussion. This point is based on a practice implication. Based on today's analysis, can we say cases involving care by paramedics are the most likely exception to a medical crisis and witnessing accident? By exception, I assume that means the most likely cases on the facts where you might be able to argue that there's still a secondary victim claim. If I'm wrong about that, I'm sorry. If the matter occurs at home, as an example, otherwise most clinical negligence cases will not acknowledge secondary victims due to the lack of duty to this individual. I think the answer there is, if you are talking about a medical crisis involving paramedics who come to the home, the likelihood is that something has happened already before that particular bit of medical treatment has been given. So we may be in different territory anyway, whether it's clinical negligence or not. So I'm not sure that's a satisfactory answer. But
I think my answer would be no. I don't think that's going to be the most likely area of concern. I mean, so paragraph 123 is where they need this teeny tiny door open.
yes,
When they talk about the rules governing claims by secondary victims, whether it could ever apply in medical setting. And the point of this judgment is they're basically trying to say, no, you are not going to have a secondary victim claim in a medical setting. However, because everyone's a lawyer and they're all judges, they can't say absolutely no, because who knows what facts are going to arise at some point in the future. So what they do say is the question doesn't arise in the present case because nobody's got an accident in the relevant sense. Hypothetical answers were put forward by the barristers, as you'd expect, posed in argument, such as a scenario where a doctor injects a patient with the wrong dose or the wrong drug, inducing an acute adverse reaction witnessed by a close relative. In our view, the issues raised by such examples are best left to be addressed in a case where they actually arise on the facts. So I think, no, a paramedic, as Charlie says, you're highly likely that there's been a crisis, there's been that the events have already occurred, which is why you've called the paramedics to them. In real time, injecting something into someone which sends them into anaphylactic shock or some kind of crisis that's witnessed has been left open as a window. The one that I think is actually the most likely is a father watching a catastrophic birth and the stillbirth of their child. So you're there and you're witnessing the unfolding of an absolute catastrophe that couldn't be much worse. You're there, you're seeing it, you're proximal in time, you're proximal in space, you're proximal in relationship, and it's unfolding. I think that is possibly the most likely, but at the moment, no.
I suppose that's then strand 2, the overarching proximity.
Come on, Del, get us back on track.
No,
yeah, absolutely.
But you meet the four. What are the Alcock control mechanisms?
Yeah.
But you've got what Paul in the Supreme Court is saying. They're saying take a step back.
Yeah.
Look at this in the normal way you would with any negligence claim. It's not just about the 4 criteria. Take a step back. Is there proximity? Is this fair to impose this burden on the defendant?
Which is what we look at in this slide. Which effectively is the rough and ready logic in limiting recovery. And they do accept there is a rough and ready logic because it's limiting recovery by secondary victims to individuals who are present at the scene, witness the accident and have a close tie of love and affection with the primary victim. The limitations are justified not by any theory that illness induced by direct perception is more inherently worthy of compensation than illness induced by other means. but rather by the need to restrict the class of eligible claimants to those who are most closely and directly connected to the accident which the defendant has negligently caused, and to apply restrictions which are reasonably straightforward, certain, and comprehensible to the ordinary person.
I don't know if this is comprehensible to the ordinary person, but maybe that's
Well,
something about me.
What they would say is that they have been presented with a problem, which is that no one knows what the law is, even though the Court of Appeal has had a number of goes at it. And they want to make that clear. And it seems to me that they have made a conscious decision to go for rough justice, which is clear, rather than nuanced justice, which is not necessarily clear.
But going back to my stillbirth problem, I do find it difficult. So while it's described as illogical for a mother not to recover for injury if she feared for the child she carries in her arms, and by analogy, the father not to recover injury fearing for the child he carries in his arms in an accident, but you're able to recover for that, but not if you're actually witnessing the child being born.
But I think is the point there that the father's not in danger, and so unlike in a road traffic accident case, you could imagine you'd try and cross-examine somebody to get them to say, well, you were more worried about the child than yourself, weren't you? Boom, your case is out.
No, that's true.
Maybe it's that practical.
But I must say, I agree with Emily. I can't see a logical distinction between that set of facts, where there is no knowledge, no medical crisis, apparently, until the moment of birth at which this happens. But again, this, on the one hand, and the cases that would, the accident cases that would recover on the other.
Hey, look, we're almost out of time. Hang on. We haven't even got there yet. Okay, so strand 2, carrying on. Where does it fit? Carrying on. It's common to all the cases of this kind. There's a fundamental question about the nature of the doctor's role and the purpose for which the medical care is provided to the patient. So we're not able to accept the responsibilities of a medical practitioner and the purposes for which care is provided extends protecting members of the patient's close family from exposure to the traumatic experience of witnessing the death or manifestation of disease. So they're making it a closed down responsibility. To impose such a responsibility, they carry on hospitals and doctors will go beyond what in the current state of our society is reasonably regarded as the nature and scope of the role. And one of the interesting tests and checks they gave themselves in considering whether it was reasonable or not was the idea that doctors would decide whether or not they should prevent patients having their loved ones sitting with them. Yeah. So if, for example, and one of the cases which is overruled, but it's a case of Zion, where a boy had a catastrophic motorcycle accident and his dad sat with him for 14 days as he got iller and iller and iller and iller and died. Whether, for example, the doctors would want to remove Mr. Zion from sitting by his son, because there could be some clinical negligence involved and there could be liability involved, because the process of sitting there is what renders you a secondary victim. Yeah. So that's one of the checks they gave themselves. So carrying on, paragraph 142, the court is recognising as analogous the category of cases in which illness is sustained by a secondary victim as a result of witnessing a death or manifestation of injury not caused by an external traumatic event in the nature of an accident, but the result of a pre-existing injury or disease. We do not consider such cases are analogous. The conclusion is reinforced by our opinion that the persons whom doctors ought reasonably to have in contemplation when directing their minds to the care of a patient do not include members of the patient's close family who might be psychologically affected by witnessing the events of a disease which the doctor ought to have diagnosed and treat. Hence, there does not exist the proximity in the relationship between the parties necessary to give rise even to the duty of care underlying it. So 2 questions really arise from that. Is one, how that applies to other professionals such as architects and builders who can advise on buildings and land that's already at risk of falling and crushing someone, and why a pre-existing illness is different. Why does it matter the starting point is internal, the primary victim? And then the second question is why drivers are meant to have in contemplation other people and loved ones that are proximate to the accident they caused by failing in their duty of care. I mean, why an ordinary person who has no relationship other than the nature of the task they're undertaking, as in driving, ought to have a wider concept of safety. But those are my thoughts.
That cross-check to me feels very much like a policy cross-check. It's just sort of, we don't want medics to be on max liable.
Well, and the corollary of it is that if you went to the other extreme, you might say, well, why, if someone could prove that they suffered psychiatric damage as a result of witnessing this terrible, terrible accident for which that driver was liable, they shouldn't be entitled to recover, even if they had no link to the person who was actually physically injured. The law has gone against that a long time ago, but there'd be nothing illogical about that. So we are in this hinterland. The main thing is, and just dealing with the next slide very, very quickly, there needs to be an independent duty which is based on the proximity relationship between the secondary victim and the tortfeasor.
So I reckon now we're 2 minutes over. I reckon we go straight to the last bit. The next few slides are all about law boroughs. We'll let you all read those over lunch, not coffee, or tomorrow afternoon.
Lunch is gone.
Lunch is gone. But the thus far and no further. Come on, Scarlett, wrap it up for us. Tell us what we need to know.
Well, I think the Supreme Court, even boroughs, he did agree with the majority judgment, said actually, you know, there was a lot of despondency saying the call for principles been called off, and they said, no, that's not right, and maybe they think they've restored it. But as we've been alluding to, we think that secondary victim claims in a clinical negligence context are going to be very difficult after this claim. There's certainly, as Emily's already told us at paragraph 123, the caveat that I'm sure many people will be hanging on to, and so there is room for argument yet. So thus far and no further remains to be seen. The impact on other person injury claims, of course, this is primarily a clinical negligence judgment, but it clearly has ramifications beyond clinical negligence, is that we think the claims in this area have been simplified because, in a way, you're looking for the accidents, is what Charlie said was. I'm going to misquote you now, but it's better to draw a clear, bright line distinction, even if it's less than satisfactory, and then it's understandable by people. So you've got an accident. Was it perceived by the secondary victim? Did it cause psychiatric injury? And was that psychiatric injury reasonably foreseeable? So rather than going through all of the hoops of how many events were there and matters of time, it's just distilling things back to that accident or incident or event. Was it witnessed? Did it cause psychiatric injury that was reasonably foreseeable? We've also said that other than clinical negligence, there are other types of personal injury claim where, because of this overarching proximity requirement, secondary victims' claims seem unlikely. So historic abuse, one will be witnessing the event, asbestosis and other latent damage cases, because there remains this need for the accident. That's the key takeaway from Paul.
We've got one final question.
Got one final question. Do you think the proximity point about doctors not owing a duty to close family members applies in circumstances when a doctor is dealing with a minor? And I take it that that's intended to mean, and therefore there are close family members around. My answer to that question is yes, I'm afraid it does. Yeah. Unless one can get in on this was really an accident type situation, then parents or siblings who witness a clinical negligence event with a child, a loved one, with a child, are not going to be able to make the claim.
Well, we know Polmear is U6, so
yes,
there we are.
Exactly that.
Yeah. Okay, there we are.
Right.
5 minutes over. Bit of a miracle.
We started a tiny bit later than 1 o'clock.
We did.
And thank you to everyone who's still with us. We hope that's been more helpful than it has been adding to the confusion. It's one of those cases where sometimes you can't see the wood for the trees. But we'll be sharing the slides after this with a couple of our typos corrected. And if you have outstanding questions that we haven't managed to answer, please drop us a line. We've got our emails addresses here on the final slide, and we'd be very happy to try and help, if not help.
Yeah. And thank you, Emma, for your thank you.
Thanks, everybody. Have a good afternoon.
You.
Bye-bye.
Bye.